All right, good afternoon, everybody. Thank you for joining us. My name is Jessica Schneider. I'm a managing attorney with the Public Interest Law Initiative, also known as PILI. Our mission is to engage, inspire, and empower those advancing equal access to justice. And specifically with our pro bono program, we want to increase the availability of pro bono legal help for those who cannot afford an attorney in Illinois. And we use innovative approaches like this one in partnering on an expungement clinic. I specifically manage PILI's pro bono programs in the northern region of the state, and including the activities of the 18th Judicial Circuit Pro Bono Committee, of which are two presenters today, and some of you are also members. We're pleased to partner with the clerk of the Circuit Court of DuPage County, Prairie State Legal Services, the DuPage County Bar Association, and DuPage Legal Aid on this event. The purpose of this training today is to cover both the process of expungement and sealing, and also cover what the day of the clinic will look like. A couple of important things before we start. If you haven't actually registered to volunteer at the clinic, but you got this link to the training, please do so. We'll provide that link in the chat. We'll also provide contact information if you need to follow up on that. A recording will be available and sent out of this training, along with some additional materials, including a copy of the PowerPoint. We will provide that. Please feel free to put questions in the chat. We may ask you to unmute to ask a question if we need more context. And you also will get a link to a CLE evaluation for credit. That is the easiest way for us to make sure you get your CLE certificate, so please fill that out. We have a lot to cover today, so I'm going to turn it over to our presenters, both of whom I've had the pleasure of working with in different capacities. I'll briefly introduce them, and then the full bios will be included along with the materials, which will be posted with the recording of the training. Stacy McCullough is going to present first. She is of counsel at Mirabella, Kincaid, Frederick, and Mirabella. She began her career at the DuPage County Public Defender's Office, where she developed invaluable trial and negotiation skills. She focuses her practice on criminal defense, and she eventually formed the law office of Stacy McCullough. She joined her current firm in January 2018 and is also a member and past president of the DuPage County Bar Association. Kim Thielbar is the director of pro bono services at Prairie State Legal Services and has served in that role since November of 2019. As director, she is responsible for overseeing and expanding pro bono opportunities throughout Prairie State's service area, including in DuPage County. Prior to that, she was the managing attorney for Prairie State Legal Services Rockford office and served in that role for approximately 5 years, where she supervised the legal work of the office, managed day-to-day operations, including pro bono, and maintained her own caseload. Thanks to both of our presenters for joining us today, and I am going to turn it over to them. Please remember, if you have questions, you can put them in the chat during the presentation, and we will let our presenters know.
All right, so hi everybody, I'm Stacy McCullough. I'm going to see if I can get this technology down. It's always frustrating to me when I get on a CLE and somebody doesn't know how to share their screen. So we tested it a couple times. Let me see if I can get it up here. All right. Jessica, good? Is it there?
That's great. It's there.
Perfect. Yep. Okay, wonderful. All right, thanks again for everybody being here today. I know I see some familiar faces. Some of you, I'm going to be talking about the same redundant things that I've spoken about before. Obviously, this is really important work. It's near and dear to my heart, as well as to the hearts of a lot of people that are on here. So I am looking forward to providing new information. If you're here for the first time, we'll talk about, really, this is about the basics of expungement and sealing and what is entailed in the process, the laws in the state of Illinois regarding expungement and sealing. And really this presentation from our perspective is going to be geared towards helping you as an attorney volunteer. So we are hopeful that if you are here, you have already signed up to help us out on Saturday, October 2nd with our expungement clinic. And you can do it even if you're not a practicing criminal defense attorney. So though my background for 8 years going on, is just as a criminal defense attorney. This is really, it's not a complicated process, particularly with the standardization by the Illinois courts of the expungement and sealing forms, the instructions. It's really quite simple for anybody to just kind of jump in and take it on. And we hope that by this presentation, as well as by the materials we've provided, that you're going to find no issues with jumping in and helping us all out on that Saturday in October. So I've already talked about the expungement clinic, and if you haven't already registered to be a volunteer attorney, I know, and Jessica, please chime in if I'm speaking out of turn, but I'm pretty sure that we still could use a few attorney volunteers. The outpouring of volunteers has been great, particularly from the non-attorney side, and that is just fantastic. Whether it's law students or paralegals, people who are just kind of interested in helping out and providing pro bono assistance in any way they can. We're really excited to have you. We could use a handful of additional attorneys, so there's 2 shifts you can sign up for, and if you go to the link that was provided or go to the PILI website, that information can be found there, so you can help us out. So hopefully you can see that whole screen. It's cut off for me, but let's see. Jessica, are you seeing up at the top? Are you seeing all those controls? No? Okay, great. All right. So let's talk about just kind of the basics, the steps that we're going to be going through here today. We're going to be talking about criminal record. It sounds basic, but how is it created? What steps are involved when somebody is taken in for questioning, whether they're arrested or not arrested, whether a criminal case is filed against them, whether an ordinance violation case is filed against them? How does that actual record get created so that it is something that now that person is facing some pretty serious implications from, that are causing a lot of doors to shut as they try to move forward with their life? Records relief. We're going to talk in detail about what qualifies for relief, what types of relief there are, when can you get that relief, and then there's also some alternatives to expungement and sealing, as well as some automatic relief from clearing your criminal record. And then number 3, providing assistance. This is kind of tailored, some of these steps, a lot of you who are participating as volunteers already on the October 2nd date, some of these steps are already in the works or have already been completed, and so you won't need to go through all of these steps. But I put all of this together with the idea that some of you might not be volunteering and you're really just here, still thankful that you're here, looking to get the basic information about how to get involved, how to take on clients that have records that they want to clear so they can move forward. All right, so with respect to that first, how is a criminal record created? I mean, it sounds basic. Somebody is taken in and questioned. They get to the police department and automatically numbers start being entered in records. Reports start getting written, whether it's handwritten or typewritten by that police officer who takes that person in. Now, it's a rare situation, but it is definitely something that you might encounter in your practice or even at the clinic. Sometimes people are taken in, they're arrested, and they are just questioned. And there is never any court case filed. And so you'll find yourself maybe searching through the online court clerk records and you can't find anything. What you need to do is figure out, well, if they haven't ever been charged with any case, there's still that record back at the police department. And that person has the right to pursue getting that erased. It can still impact them in certain respects of their life. So once that record is created at the police department, again, whether it's from just an arrest and no filing of charges, or if charges are filed and a court case is brought, those records are transmitted for the most part from the local arresting police department to the Illinois State Police. So the Illinois State Police are tasked with maintaining all of the arrests and fingerprint records for people arrested throughout the state of Illinois. Just a quick note on that we might cover a little bit later. One of the issues that you might encounter is that the Illinois State Police is not necessarily going to have, and won't have, in fact, records where somebody is, for instance, just ticketed, let's say for an ordinance violation, or a situation where they're brought in for questioning, and then rather than being put through the booking process where their fingerprints are taken and where their mug shots are taken, where they are just handed a ticket, maybe a local ordinance violation. Maybe a person has a retail theft. Maybe they've, made a poor decision at, say, the Glen Ellen Walmart, and the police, once they get that person back to the station, they determine that, you know what, they don't have any other history. They are remorseful. The items were returned. A number of different things go into that charging decision. And so instead of putting them through fingerprints and mugshotting, they'll just issue that person an ordinance violation ticket. Now, that person will still go to court for the Glen Ellen ordinance violation, but that particular case won't be showing up at the Illinois State Police records keeping. It won't come back on a fingerprint background check. And that's because that person is in that situation has not been fingerprinted. So it's always important, again, I'm kind of going off on a sidetrack here, but it's always important to make sure that you're checking all of their records, whether that's their Illinois State Police, what's called access and review background report, or if you're checking the online court records. So the Illinois State Police then will send off that information to the FBI, because obviously there's a national database. It's not like you can just leave the state and your criminal record, your arrest history doesn't follow you. On the court filing side, once that person is arrested at the police department, they transmit that information to the circuit court clerk. They, of course, forward it to the appropriate prosecutor's office, whether in this case we're talking about the DuPage County State's Attorney's Office. They'll transmit it, say, to a local prosecutor. Again, the Glen Ellen prosecutor will prosecute their own ordinance violations, and so that's a private firm. So they will have records of that as well. So whatever the prosecuting authority, obviously, they will also have records. So the circuit court clerk will open up a file, and necessarily that generates records on their part. One thing that I didn't put in here, and it's just something to keep in mind, is I hear this from a lot of clients. We go through the expungement process, we get their records expunged, and unfortunately there was a police blotter. There was a little media story, whether it's in the Daily Herald or the Chicago Tribune, in the case of a major offense that maybe is sealed down the road, maybe it was picked up by the news, maybe Fox News or, NBC, Chicago, or whatever the case may be. The Patch, the local Patch Chronicles, and all those sorts of little local news papers and media outlets. They might have picked up the story. A lot of the police departments will send their records of arrest to the media, and as keeping the community safe, keeping the community advised. So, unfortunately, expungement process doesn't cover those sorts of records. Rather, the law is simply directed at law enforcement agencies, the records that are generated by law enforcement and governmental agencies. The Daily Herald is not a law enforcement agency. So what do you have to do with that? I can answer any questions on that kind of down the road, but generally what you can do is you can send a letter. Once your client's case is expunged, I've had really good luck in sending a certified copy of the order to expunge off to the Daily Herald. Emailed the website for the Daily Herald. Google's another story, but if you get that underlying media outlet to take that off and you show them, look, this has been expunged by court order, I really have had great success in getting those sorts of records removed. You don't want to advise your client, go ahead and pay mugshots.com $500 in order to get that record released. We send that order to mugshots.com as well. Perhaps not with as great of success, but try it nonetheless. So, why is this work important? Why am I so passionate about it? Why are so many people on this Zoom passionate about it? It goes without saying, and particularly given our last year, it's devastating to people, whether it's a mistake that you made when you were 18, you were caught with alcohol when you were still a minor, you stole food from Walmart. I've had, unfortunately, clients who have stolen or perhaps sold drugs in order to pay their rent, in order to put food on their table, to buy diapers. And those are, of course, the heartbreaking ones. But there are people who obviously make mistakes, and they shouldn't be paying for it for the rest of their life. They find themselves being denied jobs. That's the obvious one, because, particularly, I guess this is not as concerning now with perhaps the number of jobs, but if you have two candidates for a job, somebody wants to go get a job at Target, and you're comparing two people with basically the same qualifications, high school graduate, prospective college student, and that one has a supervision even for retail theft and the other one doesn't. Well, who are they going to pick? And that's obviously something that needs to be erased if possible. And too many of the young people in particular don't know that they can erase these sorts of things. Housing, with the unbelievable housing issues going on during the pandemic, and evictions and the holds on evictions and things like that. If you have criminal history and you're getting kicked out of your current place and you have to go find a new place, you're going to be potentially facing denial of a lease based on something that you have done in the past. Drug cases, even cannabis, those can result in a college student being denied federal loans. Education, again, these are all things that, we're talking about public record. If there's anything on the internet about it, they can make the choice to not admit you. Travel, those things are obvious. One of the things that has affected a lot of my clients is they find themselves some 20 years after making a poor decision, unable to volunteer at their children's school. They've gone beyond it. They thought it was past them. They don't know that they can actually seal perhaps a conviction or expunge a non-conviction, and they can't volunteer to bring lunches in and be a parent teacher mom or whatever they call it nowadays. My kids are old, so but those are obviously the things that people are concerned about, why this work is so important. So the Fair Credit Reporting Act says that private background check companies can report non-convictions for 7 years. They can report convictions forever. Now, this doesn't apply to law enforcement background checks that are done, like I mentioned earlier, through the Illinois State Police or the FBI, so that if you are submitting fingerprints that are taken for, say, a job in nursing or something like that, that case is still going to come up on your criminal background check, even if it doesn't come up on your Fair Credit report. This website is incredibly helpful, and earlier when I was practicing sharing my screen, I tried to take this link and it didn't work, so I'm not going to do that, but the slides will be provided to you. This is kind of an obscure link that I found a few years ago, and I find it really helpful because sometimes there's a situation where you have a client and they come to you and you're not really sure if it's going to impact them in their particular line of work. For instance, is a battery charge going to affect somebody who is in the banking industry? So one of the things that you can do is you go to this link and you search a nationwide database. So, if they are planning to move, I had one client who planned to move to Arizona, and she was trying to get her mortgage broker's license, and we were able to find out exactly how the proposed sentence was going to impact her there. So you choose the state, you choose the consequence type, and those are listed as education, employment, banking, fraud, volunteering, and then offense type. Obviously, is it a felony? Is it a misdemeanor? Is it drugs? Is it violence? Is it a crime of dishonesty? And then you can figure out, well, really, what are going to be the collateral consequences that my client is going to face with the type of disposition that is being proposed? Or on the other hand, what type of collateral consequences my current client facing right now when I'm trying to get his or her records sealed or expunged? And that's an important thing to kind of look up and to know, because sometimes a judge will say to you, well, what's the difference? How is this impacting your person? What is it that they want to do? What is their goal that they have? why should I get rid of a supervision for a battery if it becomes an issue, if there's an objection in a hearing? And you want to be able to say, well, Judge, look, she wants to get into the banking industry, and she knows that even though this is a non-conviction, that this is going to affect her. And here's how I know that. And this link will actually provide you with the statutory site for that particular state to tell you, here's the law that you can point to that says this is going to be a problem for that person. All right, so what is the law? Jessica, did we share my tardy handouts?
Yes, I put the link, or Abby put the link in the chat at the beginning. Great. There's a link that says handouts.
Okay, great. Thank you, Abby. And I think, Jessica, you had mentioned too that they'd be available on the PILI website.
Yep.
Great. So my apologies to everybody. True to form, I am always making changes and adding things and wanting things to be perfectly straight. So even the handouts that you have from me in the chat box, they're a little bit crooked because I just couldn't get our scanner to work and make it straight. So my apologies that this is not emailed to you beforehand. That is always something that bothers me. So I was guilty of it and I apologize. But hopefully you'll find the materials that I shared helpful, and Kim's materials are amazing. So those will be incredibly helpful. So the law is printed out in your materials, and it's not that lengthy. It's certainly not like the 700+ page latest crime reform bill that we are dealing with. So I printed it out because I wanted to make sure to highlight some of the important sections, and hopefully you find that helpful as well. So when we go to that law, it talks about definitions, and I'm a big fan of actually having my books. I have them in the back. They're always sitting next to me, and they've grown from maybe an inch wide at the criminal code to now, I don't know, it looks to be about 3 pushing 4 inches, but I have to have the book in front of me. And I really encourage you, it seems commonsensical, where, for those lawyers, even for those paralegals, pull open the statute. And I actually find myself, I was reading it again today, even though this is something that I do all the time, if you go to that law and you actually highlight it on your own, so that's why I didn't highlight all too much. I put these sticky arrows for you, but if you print it out and you go through it, it's really going to be invaluable. Certainly, the way that the criminal code is written is you have to go flipping backwards, forward. Well, what is that section referring to? If you don't know, the statute site for DUI is 511, blah, 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 5, 6, whatever the heck it is. You don't want to have to see, oh, what is this saying is excluded from relief? But take a look at it, read it, because, anytime somebody asks me a specific question, that's where I first go, because having done numerous presentations on this, having heard numerous presentations on this, the amount of information that is on the internet from PILI, from Prairie State Legal, from Cabrini Green Legal Aid, Legal Answers Online, all these different services have so much valuable information, but you always want to go back to the law, because I'm human. You want to rely on the statute rather than relying on these slides, these fancy slides and graphics and things like that. So make sure you take a look at the actual statutes. I've included in the materials the statute for both the adult and for the juvenile section. I will tell you that we're not really going to cover juvenile here today. It's a whole different beast. It's obviously, it's been simplified quite a bit, but I also have attached to my materials the forms that the Illinois courts have put out, the standardized forms, and those are very helpful because they actually have some of the statute citations and the explanation of what you can and cannot do. Should I take some of these chats? I see that there's 10 chat questions. Should I stop, or are those things, I'm not looking at them?
Nope, you're good.
Okay.
Kim and I have been answering them.
Awesome, thank you. All right. So those forms are in here, and in particular, the juvenile one is something that I want you to take a look at, kind of on your own time. We're not really going to cover that in today's presentation. All right, so getting to the bulk of it. What can be expunged? Non-convictions can be expunged, and non-convictions includes all of these listed dispositions. If you're found not guilty, If your case is dismissed, and by dismissed, that can mean nollie pros, non-suit, SOL, no probable cause, supervision. That's a non-conviction. There are exceptions. Non-convictions also include things like first offender probation. So if you have a client who is charged with a first-time class 4 possession of cocaine, and they are sentenced to first offender probation, that is what's called a qualified probation. And after that person's sentence is done, it's considered a non-conviction. And it is a situation where not only can it be sealed, but it eventually can be expunged, even though it's a felony, because it's a non-conviction. Second chance probation. One of the things that I didn't list in here, and I'm going to make a note to add, is a diversion program, and that's something that even in Kane and DuPage, in Will, all surrounding counties here, they do have diversion programs. And if a person is sentenced on a felony to a diversion program through our DuPage County, it's through the state's attorney's office, and if they successfully complete the terms of the diversion agreement, even though they've pled guilty, at the end of that term, that charge is actually dismissed. And so that's different than second chance probation. And this is something that came up when I was charting a couple of things. A second chance probation, when the case is done, when that person has successfully completed all the terms of the probation, whether that's public service, restitution, SWAP, which is public service or community service through the supervision of the sheriff's department, any other conditions, counseling that they might have to do. Once a second chance probation sentence is done, the technical term, and I'm going to try to get this right, the proceedings against the person are dismissed, and the conviction is vacated. However, in that situation, there's still a waiting period, and that is different than a diversion agreement. A diversion agreement falls under that category up there of nollie pros. You complete the diversion agreement, and for the most part, the charge is going to be nollie pros, so that there is no waiting period. Task probation is treatment probation, and that applies to straight task probation, not regular probation with task as a condition. So if you're volunteering with us on that Saturday and you see something that says task, make sure that you confirm that task designation, you're going to want to go to the sentencing order, for instance, make sure that it is actual task probation and not probation with task as a condition, just to confuse you. But I'll be at the clinic in case anybody has any questions. All right. So what can be sealed? Convictions can be sealed. And one of the most important things that I want you to take away from here is if you have never done this kind of work before, you have a client who has been convicted 6 times of burglary, a class 2 felony. They've gotten probation, they've gotten county jail, maybe on their 3rd or 4th one, they went to prison, they've done boot camp, whatever the case it is, but you know that they have conviction for a burglary, class 2 felony. Doesn't matter, that can still be something that is eligible for the filing of a request for a petition to seal. I'm going to say this out loud, and it's going to be a very rare situation, but a murder conviction is eligible for a request to seal. Domestic batteries are not. Violations of order of protection, you can see at the end of this slide the things that are not eligible. Things that, sex offenses involving minors, cases in which you have to register as a sex offender, those cannot be sealed. Reckless driving with limited exception. DUI, whether it's supervision or it's a conviction, can never be expunged, can never be sealed if there is a disposition. And by disposition, I mean an actual sentence has been imposed, whether it's supervision, which is considered a deferred disposition and not a sentence technically. But if there's a not guilty, or if the case was dismissed, if there was a finding of no probable cause, that is a situation where a DUI can actually qualify for expungement. But we did have a number of people who came attempting to get us to help them with their DUI. Doesn't matter if it was 20 years ago, 30 years ago, 5 years ago, a DUI and a domestic battery conviction cannot be sealed or expunged. So there's a list of delineated offenses and dispositions that absolutely cannot have any relief. So if you are looking at a criminal record, and again, this is kind of more for those of you who are looking for basic information and not helping us out at the clinic, but because that information is already going to be provided to you. But if you're looking at somebody's sentencing order, if you're looking at the clerk's public records, and you're looking at the information that is input there on the online system, if you see anything that says conditional discharge, sometimes abbreviated as C/D, probation, where it's not first offender or second chance or task. If you see that person has done even 2 days in jail and been sentenced to 2 days in jail, time considered served, sometimes it'll say TCS, prison. If there is something that indicates fines, court costs assessed, and nothing that indicates supervision, that's a conviction. And then unsatisfactory termination. So if a person gets battery, a supervision for a battery rather, and they've been ordered to do 50 hours of community service, they come back on their 1-year return date, they haven't been able to do it. It's shown that they willfully violated their supervision, and the judge revokes that supervision and issues a conviction or puts them on conditional discharge. That is an unsatisfactory termination of their supervision, results in a conviction, but that can still be sealed. You can no longer expunge it because it's been changed to a conviction, but you can still seal that particular disposition. All right, so.
Hey, Stacy, we
Yeah.
did have one question and I might need more context for it, but someone said off call, can that be expunged?
You know, that's a good question, because that's something that having practiced in Cook County, I think that that's something that often happens in Cook County. I would think that generally it comes with an SOL/off-call thing, where I don't really, I haven't ever seen that in DuPage County, but good question. And I think if it just says off-call, I guess my question would be, well, off-call, does that mean that somebody can then bring it back on call? Because it's not really a formal disposition. So, but then what do you do in that situation? I'm just going to speculate, you know, do you have to motion it back up? Do you have to then go ask the judge, you know, this could be some 2, 3, 4, 5, 10 years later, and it just says off call. Do you have to go back in and ask the judge, well, what's the actual disposition? Because in all likelihood, and again, I'm not all too familiar with all of the acronyms and initials and shortened versions of dispositions that they have in Cook County, but off call to me in Cook County would mean if a long enough time has passed, I'd go ahead and file that request to expunge anyway. And you know, because if you file it, are they going to object? Is the state's attorney going to object? Is a judge going to not grant it when the judge has that same file in front of them where it says off call? If it's a case that had been, you know, some years ago. Obviously, off call in that situation to me means it's eligible for expungement, but that's not delineated in the statute as a authorized disposition. So I hope that answers the question. I can't see the chat, so I'm electing to not open them. So, all right. So, you know, the difference between expunged and sealed, and that definition is in the materials. I found a kind of a interesting little document that I did attach in the materials. I found it interesting. That's because I'm a geek when it comes to these things. But expungement under the definition of the Illinois State Police is to physically destroy the records or return them to the petitioner, and to obliterate the petitioner's name from any official index or public record, or both. Sealing, on the other hand, means to physically and electronically maintain the records, unless the records would otherwise be destroyed due to age, but to make the records unavailable without a court order, subject to some exceptions. So really, that's the definition. You know, again, I've listed it out here. If something is expunged, what the statute says is the effect of an expungement is, highlighted this one. The effect of an expungement is basically to return the person to their status back before the arrest even happened. It is truly, and I tell my clients this, if your case is expunged, it is truly as if it never happened. And you get to represent if anybody were to ask you. If somebody says to you, do you have any expunged records? Number one, an employer is not supposed to be asking you that in 99% of the situations, but you're allowed to say no. You get to lie, to be perfectly frank. And the statute says you're returned to your status as it was before this case even existed. So sealing is just that. It is, they are sealed, but they're still there. And the access to sealed records is different, so that if a record is sealed, law enforcement still has access. All right. For the case of felonies, if a record is sealed, those are still going to be accessible to employers who are authorized by law to request your fingerprints for a job. Hospitals, schools, daycares, nursing homes, things like that. There's no private entity access to sealed misdemeanor cases. And really, let's be frank, the thing that people come to you the most for is, look, I can't get a job, I can't get a promotion, I can't get housing. And they are just delighted to hear that if their record is sealed, their prospective landlord is not going to be able to see those records. And that's what they want to hear. They want to hear that they're, perhaps it's an entry-level job even. They want to hear that if they're going to target to get a job, that a record that has been sealed is not going to show up. So that's really important. That's sometimes people are disappointed when they hear, oh, you mean I can't expunge it? Sealing is great. I highly recommend it. It helps so many people, and it's okay that it's not expungement. So make sure that when you're talking to people, you don't say, flip it around, make it positive. Hey, your record can be sealed, even though it can't be expunged. Not, sorry, your record can't be expunged, but next best thing is it can be sealed. You got to be positive with it, because this whole sealing thing, Illinois is just incredibly progressive on this, and it's really benefited so many people. So it's a good thing. All right. So waiting periods. The waiting periods are pretty basic. If there is a supervision, sealing. I have put these all backwards, I see. Sorry about that. All right, so we'll talk about sealing waiting periods. So on a conviction, this is the one that's kind of more complicated. If somebody is convicted, they get conditional discharge for battery for 12 months. At the end of that 12 months, let's say I didn't do my public service. It's unsatisfactorily terminated, but I already have a conviction. I can still seal it. I have to wait 3 years from the time that conditional discharge ends in order to be eligible to file a request to seal and to have that granted. But I can still file that, even if I have unsatisfactorily terminated my probation, unsatisfactorily terminated my conditional discharge sentence, or if I've satisfactorily terminated my sentence, I can file a request to seal after 3 years has passed. Now, the caveat is, during that 3-year period, you can't have anything else. So let's say I'm in the midst of my waiting period. I'm 2 years out. I'm 2 years and 11 months out. And then all of a sudden I get another case. I get a retail theft and I get convicted on that one. My 3-year waiting period has just started again. And it's not just a 3-year waiting period for that new retail theft. It's a 3-year waiting period for that battery. So you got to make sure that you emphasize to people, you can't have anything during that 3-year waiting period. And if there is something that comes up in between, your 3-year waiting period starts all over. So it applies to all of your cases in your background. If I have somebody who has a conviction 20 years ago for battery, and in the last 3 years, they have a new case and a new conviction, they got to wait that 3-year period, even for that prior in 20 years ago. All right. Qualified probations, it's 3 years from the completion of your last sentence. So this is a tricky one a little bit, because I have this situation for someone who we're going to be helping out at the clinic. If you have a qualified probation, second, let's say it's first offender probation. So I'm going to be eligible to, that person's going to be eligible to expunge it 5 years from the time their sentence ended, but they're eligible to seal it 3 years from the time the sentence ended. So this person particularly is eligible for sealing right now, but they have to wait another 2 years in order to be able to expunge it. That can become tricky because I know that the records are gone from public view, but rest assured that the clerk's office does keep, again, those records. They are not destroyed. So as long as that person still obviously has their information, they can go to the clerk's office and file that expungement. And there's a benefit to that. You know, certainly expungement is better than just sealing, because once it's expunged, they get to, law enforcement doesn't have access to it anymore. There's no waiting period for acquittals or dismissals for sealing. So this is a situation where, let's say I've gone to trial on that person's battery and they're found not guilty. There's no such thing as immediate expungement. You can certainly go downstairs to the clerk's office, file your petition to expunge once you get that not guilty verdict. But for sealing, you can ask for that immediate sealing from the judge. And I'm not going to claim to know how this works, and I don't want to speak out of turn because I know that our circuit court clerk is on here, so I don't want to get it wrong. But understand that you can get an immediate sealing for an acquittal or a dismissal. You take care of that day, and then you're still going to want to follow up though with filing the petition to expunge. When it says immediate, it just means you're going downstairs to the clerk's office, and my understanding is right away that record is being sealed. You're going to file that expungement though, so that the waiting periods will apply, so it's not as immediate. I probably butchered that, so we'll make sure that we clarify that. All right, so expungement waiting periods. I put these time frames in here, but I will tell you that in DuPage County, they are not, I hope I'm not giving away any great secret, but if I have a person who had a diversion or a deferral program, say from the city of Naperville, or I have that person who is found not guilty, or rather a case is nollied, because there's no complaining witness on the trial, I can still go ahead and file that petition to expunge right away. I have never waited the 120 or 160 days in order to file it. And truth be told, the order is not going to be entered for some time in any event. So technical waiting periods aside for acquittal and dismissals, I would go ahead and file that request to expunge. Supervisions, a number of the most of the offensive supervision, there's a 2-year waiting period from the time you satisfactorily terminate your supervision. And there is not a similar statute or section as there is for sealing. In other words, if I get supervision for my battery, it's terminated, and I'm in that 2-year waiting period, and I get something else in the interim, certainly it's going to be considered by the judge as to whether he or she is going to grant my relief and my request to expunge, but I can still go ahead and file a petition to expunge, even if I pick up another offense during that 2-year waiting period. Again, I'm not sure that's really advisable, but that's what the law says. Qualified probations, again, 5 years from satisfactory termination, and same thing for task. There are some supervision dispositions that have a 5-year waiting period beyond qualified probation. I know that is indicated on the forms. So this is a really big one, and it's unfortunate that really that this notice can't be posted somewhere in the courtrooms, or that all attorneys can't just make it a regular part of how they advise their clients. So if I have a client who is getting probation for a burglary, and it's a 2-year period of probation, once that probation terminates, whether it's satisfactory or unsatisfactory, to be honest, I can file a petition to seal on their behalf 3 years after they have terminated the probation. However, if during their 2-year term of probation, they earn a diploma, a GED, an associate's degree, a bachelor's degree, and this is the greatest one, a career center certificate, a training, a vocational school certificate. It has to be, you know, a cosmetology certificate, something of that nature. it's really undefined in the statute. You can go to the sealing section and see the precise words there. But if you earn that degree or certificate during the term of your probation, you don't have to wait 3 years. You can go and immediately file a request to seal once your probation is terminated. And it's something that I even find myself now. I forget to tell people, if they have the opportunity, go ahead and get that education, get that degree, because then you don't have that 3-year waiting period, and that's fantastic. All right, so the forms, again, here's the link, and Kim and I have both provided those forms. They are super self-explanatory, and they are on the site. The Illinois Supreme Court just recently modified, changed their website. I find it a little bit kind of confusing to find the standardized forms. Hey, Jessica, do you have control of? Thank you. So in one section, you can go to that link there and you can find the forms under standardized forms. And another one, you go to it, you can't find the standardized forms for expungement. Everything else is there. So you might have to do a little bit of digging. So they're great help. And I know that Kim's going to go through those. All right, so what happens after filing? I go to the clerk, or I sit at my computer, I e-file it, and the clerk gets a copy of my petition or request to expunge or seal. From there, the clerk will send out copies of that petition to the state's attorney, to the law enforcement agency who arrested my client, as well as to the Illinois State Police, regardless of whether or not my client was arrested. So again, I kind of go back to that situation where a person has an ordinance violation and they were never actually arrested or fingerprinted. That request, that petition still goes to the Illinois State Police, and they might at some point send back something that says, we don't have any records of this person, and that's okay. That just means that they weren't fingerprinted or that their fingerprints weren't forwarded on. As an aside, if a person is arrested for an ordinance violation, oftentimes they are actually fingerprinted, but those fingerprints are kept internal to the arresting police department. That happens a lot here in DuPage, particularly with kids who are maybe arrested for, going back to that Walmart retail theft example. If they'll take a minor in and they'll print them, but those prints aren't getting sent off to the Illinois State Police. They're staying internal to the police department. And in DuPage, and again, I want to clarify that this is something in DuPage only. So grateful because we don't have to file the notice of filing of the petition or request to expunge. I will say that it's not tedious work at all, but in all of our surrounding counties, we absolutely have to file the notice of the request to expunge. And that just a little bit on that. The biggest difficulty that we have is you have to list, you list the address of the police department that arrested the person, and then you have to list the chief legal officer for that particular town. And so oftentimes we're left wondering, well, what does that mean? I mean, clearly for the city of Naperville, the chief legal officer for the Naperville Police Department is the Naperville Legal Department. They have their own legal department. So it's either Joe Solon or Chris Holland. You send it to their office. Glen Ellen, I know that if it's an ordinance violation, I'm going to send it to Smith and Fuller. If it's a DuPage County Sheriff case, their chief legal officer they're the state's attorney because they are represented by the state's attorney. The one issue that we have is, what if it's a department where you don't know who their chief legal officer is? So you're left to question, am I sending it to the mayor? Where am I sending it? Oftentimes, this is just a little tidbit that I've found works. If you go to the city's board meeting minutes, agenda meeting minutes, the minutes of their board meeting or their commission meeting or their city council meeting or whatnot. And I've done this on a lot of cases when I file these in Cook. Go to their meeting minutes, and oftentimes you're going to see city attorney, and you just get their name right off of that, because sometimes you call the department and they don't even know who their chief legal officer would be. And I'm certain that the mayor doesn't want all these petitions being directed to them. So that's just a little helpful tip. All right, so one thing that you want to emphasize to the person that you're representing is that, look, from the time I file this at the clerk's office, nothing is going to happen on our end for a minimum of 60 days. So that there's an objection period built right into the statute. It's a notice period because all of these agencies that have records of your client's arrest and court case have the right to have notice and to object and to be heard if there is an objection. They get to have their input naturally. And so that notice period, that 60-day clock, starts ticking from the time they receive it. So I won't name the county, but it's certainly not DuPage. Oftentimes those petitions sit at the clerk's office after I filed it, and it's going to sit there for 2 weeks, 3 weeks, 4 weeks, a couple months maybe, before it actually gets sent out to the arresting department, to the Illinois State Police, to even the state's attorney. And unfortunately, that 60-day time frame doesn't start clicking because the statute said it's 60 days from the time of service. In any event, not an issue in DuPage for the most part. Okay, so it's sometimes the Illinois State Police sits on a pile of them and they don't, they'll get their little green card, and I don't know what happens to them from there, but they got a lot of volume there, but they're really, really good about complying. And I can't remember the last time I had an objection from the Illinois State Police. So once that 60-day time frame has passed, and this is different for our expungement clinic, but in general, outside of the clinic, if there's an objection, and in general, any objection is going to be filed by the state's attorney. If there's an objection, the notice of the objection is a document that is filed by the state's attorney. They have a form. It's very clear. They check a box that either says, defense attorney, you don't know what on earth you're doing. We're objecting because this person is not eligible. And it could be, quite honestly, that the person had not been fully honest with you in disclosing their history. They might have something from Lake County that you just didn't see on their background check, or, and so that's one thing to emphasize with your client is, look, it's really important for you to be forthright with me about anything that you have, whether it's in this state or any other state, this county or any other county, because those other counties, those other cases can affect your eligibility, can affect your waiting period in the case of sealing as well. So remind them to be honest. And if there is an objection filed, the state's attorney will send you that written notice, and it will have a box checked. They'll send that notice to the clerk's office, and then the clerk will schedule a hearing. It will naturally be 60 days after the last date of service. That waiting period's got to expire. And so what happens at that hearing, and I will say that it used to be, more common, and it's not anymore. Thankfully, it's been really quite wonderful that there are not as many objections based on nature of the offense. I will tell you, and again, speaking directly about DuPage County, that if your client has a domestic battery and that domestic battery has been nollied, you're getting an objection. It doesn't matter if your client had a defense. It just doesn't matter. It's based on the nature of the offense. And you got to understand that. And, they're going to object just because it's domestic battery and due to the cycle of violence and things like that, because otherwise we'd have people, well, anyway, I'm going to go back on track. So they're going to object on that. They're going to, object if it's an aggravating case, if it's a aggravated battery that was amended to a battery and there was horrible facts, but your client had amazing mitigation. But they've gotten the benefit of an amendment from a felony to a misdemeanor, you might draw an objection based on that. What else? Alcohol-related offenses. I had a client this morning who had 3 or 4 consumption of alcohol by a minor. Now, they were 11 years ago, but they objected. And I understand that because, this person have a pattern. I mean, okay, they were obviously underage and now they're older and doing well, but it's kind of the whole DUI mindset. They're going to object on those cases that are kind of hot ticket items for natural reasons. If you get a hearing date, you're going to be on Zoom, and it's going to be either before the misdemeanor presiding judge or the felony presiding judge outside of the clinic, and you're going to have your hearing. And I know that my time is kind of running short, so I just kind of go on and on and on. But as far as the hearings go, I can certainly chat with anybody off the CLE here and talk about what really happens at the hearing. Just real briefly, the state will give the reasons for the objection. Depending on the judge, you might not have to say anything. So you just wait and see if the judge wants you to say something. Now that we're in Zoom world, our clients generally don't have to be on. In a lot of situations, and Prairie State is super about this, they prepare an affidavit in advance if they think that it's a situation, and maybe they do this in all cases, so I don't mean to misspeak, but the affidavit that they prepare is anticipating that there might be an objection, and it talks about all the good things about this person in advance, maybe to stave off an objection. If the person has a lot of criminal history, they put together an affidavit that talks about that person's good character. They lay out the things that are talked about in the statute as far as when a judge, what a judge should consider in granting or denying a petition. That person is working, or that person is unable to move up in their position. They're unable to find a second job. They are unable to get housing. It's affecting their ability to take care of their children, put food on the table. They've learned their lesson. They've gone through extensive counseling, all these good things that, and they put in that affidavit to, stave off an objection or to prepare for the hearing. If there is no objection, then you're just going to get that order granted in the mail from the clerk's office. After it's done, the presiding judges just sign stacks where there's no objections. They sign stacks at a time after their waiting periods have passed, and they send them off. When that clerk is sending off that order to expunge or seal, they're sending you a copy, they're sending the law enforcement agencies a copy. And again, that 60-day time frame comes in. So they are guided, they're directed to comply with the order to expunge or seal their records within 60 days from their receipt. And again, it's from their receipt. If you are getting delays from the Illinois State Police, for example, which was commonplace during the pandemic, they were understaffing their office. So they're pretty decent now, but give them a call. They're really good about saying, oh, it's coming out on this day, on that day, or whatever the case may be. You want to tell your client, we're talking a lot about timeframes here. You want to tell your client, this is not something that happens overnight. I tell my clients at a minimum, when the time comes that I'm filing it, you are looking at a minimum of 5 months, maybe 6. And that's DuPage County, and that is quick. And that's just taking account of the time frames, not only of the objection periods, but also the fact that there are so many of these petitions out there, the clerk can't possibly schedule them all for the same week. They just can't do it. So keep that in mind so your client knows that it is a process, and understand that until you get something back from the Illinois State Police, from the law enforcement agencies that say, we have complied with the order to expunge, we've complied with the order to seal, those records are still out there. So I know a lot of clients will say, well, I have a job interview, the day after the expungement order. It's still going to be there. It's still going to be there till you get that compliance. Again, I've touched on this, what the court considers. They consider strengths of the state's case, this person's character, what good things they've done since this offense, how much time has passed since the offense, and things like that. Adverse consequences if it's denied. Is this person already a CEO? And that's great. And I'm not suggesting that should be held against this person, but is this a person who is facing an inability, a complete inability to get a job, whether it's, a mid-level job, an entry-level job, it doesn't matter. You need to be able to explain to the court what are the barriers that this person has faced, and why, if there's a strong objection, should relief be granted, because it's always discretionary. And sometimes people want a guarantee. When I say they're eligible for expungement, that doesn't mean that it's automatic. It doesn't mean that it's going to be granted. We're going to kind of skip over this because we're not talking about these, but if there's, situations where somebody is just not eligible based on statutory reasons, they can seek alternative relief. This one confuses the heck out of me, I'm not going to lie. And as I read what I typed, I've been asking Jessica and Kim and Mia to help me wrap my brain around cannabis expungement, whether it's automatic. Wow, what's a minor cannabis offense? So I'm going to direct you to Kim's amazing handout on this point, because I pulled the information from this slide as best I could from her handout. She's got a cannabis expungement cheat sheet. And I think that, just a couple points here. Minor cannabis offense is possession or delivery of 30 grams or less. And that's important because as you read through the statute, and I have highlighted in my materials in the statute, the definition and this particular section, it's at the very end because it was added on just recently. The definitions are very important here. If you have a person, there's certainly a great number of cases are eligible for automatic expungement. Don't wait for that, because these are things that the clerk's office and the law enforcement agency, everybody can comply over time. And I understand that because the volume of cases is so great. But don't wait for automatic expungement. If your client's eligible, go in and do it. Request that expungement, because you know that one's going to be granted. You're just not waiting for the automatic. Convictions for minor cannabis offenses. So, and somebody please correct me if I'm wrong. If I have a client who's convicted of, he's got a conviction for a class B, he had conditional discharge for possession of between 2.5 and 10 grams of cannabis, but it was a conviction. That's one where we are going to file two things. We're going to file a request to expunge, but we're also going to file a motion to vacate, because you've got to vacate the conviction before you can expunge it. And those are all going to be filed at the clinic. So those are things that you can file together. And this was kind of a stumbling block in my head, is I thought, do I have to file a motion to vacate with the judge who heard the case initially and motion it back up and pay a $40 motion to vacate fee and go before, you know, the judge in 4001 or whatever, where the conviction entered? Or I just file, and this is what I've come to understand, you file the motion to vacate with the request to expunge, and it's going to go, if there's an objection, it's going to go to the judge for hearing in the expungement call in 4003. So those forms, we will have those. They're being treated differently, and there's two things that have to be filed on those particular types of cases, convictions for those minor cannabis offenses. I did include in my materials, and please, please, please don't use them. I provided in my materials the drafts of the Illinois Supreme Court's form for the motion to vacate and expunge eligible cannabis convictions. And it's marked draft, and that was marked draft by the Supreme Court when they put those forms up on their Illinois court's website. When they have the access to justice is just great, and they're putting new forms for self-help all the time, and they put them out for a time period during which you can review them, review and comment period. And so these are no longer on the site. They haven't been published yet. I put them in here because it helped me to understand, and hopefully it helps you to understand under what circumstances you got to file that motion to vacate, when you can, when you can't. If your cannabis matter, if I committed, stalking, and I get arrested for stalking, and I happen to have, 25 grams of cannabis with me, my cannabis case is not going to be automatically expunged. 2, automatic expungement is not applicable to local ordinance violations. So your city of Naperville cannabis possession of 2.5 grams, that's not subject to the automatic erasing. You have to file a request to expunge on that. So if it's a local ordinance charge, even though it should be automatically expunged, if it was a state charge, you got to go and affirmatively file that motion. Also ineligible possession of less than 500 and manufactured delivery of less than 30. Okay, these are my forms. I am not going to go through my forms because Kim is going to go through these. They're more appropriate for what's actually going to happen at the clinic. This is a chart, just real quick. This is the chart that you're going to see. This is the information, and I picked a really simple one. I should have done I had a more complicated one. Lisa from the clerk's office had given me all this great stuff, and I just ran out of time to put it all in here. So next year, I'll use all that stuff. But this is a real simple one, and these numbers correspond to my other forms. This website, invaluable, naturally. This is where we get all the information if we don't have an access and review report. This is the access and review report. So this is what, if you're charting or if you're starting out, if you're representing somebody, this is very helpful. And again, I won't go through all these, but the numbers are pretty self-explanatory. If you have any trouble understanding my cryptic notes here, just let me know, send me an email. This is a sentencing order, and this is what you're always going to want to pull up and say, hey, look, does this sentencing order match what is reflected on the Illinois State Police Access and Review Report? On this situation, it was different. So what controls? Well, the sentencing order does. And it might be a situation where you want to try and get the ISP to correct the record, unless it's going to be expunged anyway, because then it just doesn't make a difference. The complaint, this is the tool where you're going to go to the most and find out your date of arrest, how many counts there were, because you want to make sure that you're covering all those different counts. And that is the end of my presentation. Sorry, I'm a little over.
No problem. Thanks so much, Stacy. When you stopped sharing, there were a couple questions in the chat, and I thought you might be able to tackle them in the chat
I
for
will.
time interest, but if not, we can always go back to them too.
I'm happy to do that. I will stop sharing. Okay.
Great, and now we will move on to Kim.
Great, thank you, everyone. Just make sure. All right, is that ready to go, Jessica?
Good to go.
Okay, so I am Kim Thielbar. As Jessica said, I'm the Director of Pro Bono at Prairie State Legal Services, and my role is to help walk you through what the day of the clinic will look like. So just some general background information. All the work you do for the clinic is covered by malpractice insurance of either Prairie State, PILI, or the DCBA. So you don't have to worry about which one covers you. Just know that you're covered, so you don't have to worry about that. We are asking volunteers to please bring a laptop if you have one. We will have some computers available, but I don't think we'll have enough for everyone. So if you have a laptop that you can bring, please do so that you can use it throughout the day to fill out the forms and look up anything you need to for the client. The charting that Stacy went through and showed you a little bit, that should all be completed for you when you get to the clinic. So we are working on getting all those charts completed so that the initial step of tracking down all the records and analyzing them should be done. You will still have to review that chart, check over it, make sure everything looks correct before going forward with the client. Each client will have their own folder of information and all the forms you need, so you don't have to worry about, getting one of these forms that I'm going to show you or talk about. I will say, except for the petitions themselves, we will ask that you have those either in your email from this training or save them somewhere on your computer so that you can fill out those forms on the computer. You're welcome to do it, by hand on paper, but it's a lot easier. They're fillable forms. It's a lot easier to get everything in there if you just do it on the computer. So please save those forms. We also can get them to you or help you pull them out the day of the clinic. But if you can save them ahead of time, that just saves everyone a little bit of time. We will be getting a volunteer instructions information form. Actually, it was part of your materials, and I'll show you what that looks like. We will also have copies of that at the clinic, so you don't need to remember every single thing, every single step. But so just be aware that exists, so you have that resource. And then finally, just make sure each client leaves with a copy of the next steps document, and I'll go through and show you what that looks like when we're done. Okay, so effectively communicating with clients at the clinic. I know you're all experienced attorneys and you communicate with clients every day, so I'm not going to give you a lecture on how to communicate with clients. I just want to touch on a couple of things that are particular to this clinic and also just generally working with clients on expungement and sealing issues. So the main thing is just to try to avoid judgment. It can be easy to look at someone's record and make a judgment about what kind of person they are or the things they've done or how they're, oh, you're so terrible, you have X and Y conviction on your record. Try your best not to do that. Remember that you're only seeing a small part of this person's life, a brief snapshot of what was probably one of the worst moments of their lives. You don't have their full history. You don't even have a resume of everything else that they have done. So try to avoid, jumping to conclusions about the person or making judgments on them based on whatever their records say. The law itself is black and white, but whatever circumstances were going on in their lives to lead to those records are not. So keep an open mind. Don't judge people based on what's in their records. And then finally, just make sure the client understands what the process is. So as you are probably learning, the difference between expungement and sealing can be confusing. So make sure the client knows what each means for them and for their record going forward. Make sure the client understands the timelines, as Stacy stressed. That, many clients might come in and say, great, I went to this clinic and now my records are all gone. Make sure they know that that's not true. This is just the first step and that they have to complete the other steps and it'll take some time before the records are cleared. And then make sure the clients know if anything is needed from them before they can file. So we want to put them in the best position as possible when they're filing the records. So if they need a drug test or if they're in a waiting period, make sure that's clearly explained and they know not only what's needed, but if it's a waiting period, when that's going to be ending. And that next steps form that each client should get will help you to do that. So procedures for the clinic. Stacy, as Stacy said, she'll be there all day. I'll be there all day. There's going to be several other people who have been helping to plan this and who have different levels of expertise on this issue. So if at any point you have a question or you need assistance, there's going to be IT people. So if you have an IT question, we're going to give you some flags. Each person's going to have a yellow flag, a green flag, and a blue flag. So if you have a question or need help, go ahead and raise that yellow flag and someone will come over and help you figure out whatever your issue is. On the day of, our clients will be arriving in 4 separate waves. So there's a 10 a.m., 11:30, a 1:30, and a 3. So when clients get there, they'll check in and we'll give them all a number. And so they'll have to remember their number, and then also their number will be on the folder. So you'll know, okay, I need number 4 or 5 or whatever the case may be. When you are ready to start working on a case, you raise your green flag and a runner will come over and bring you a folder for the client you have to work on. It's important to please try and keep track of when you start working on a case and also when you finish. We would like to collect how long it takes, how long people spend on each client's case. This helps us. Partially, we need it for some grant reporting, but mainly it helps us to plan for the future. If we know, okay, on average, it's taking people 45 minutes or half an hour or an hour and a half, that helps us to plan for the future. And if we do this again, then we know better how to schedule people and how often we can schedule people. So please, please, please make sure to check the time when you start working on a file and then when you finish with the client, and write that down on the volunteer attorney final report when you're done. Okay, so then after you get the folder, you look at the client's chart, make sure you understand everything on there. Again, if you have a question about something or you don't know what something means, go ahead and raise that yellow flag and we'll come help you figure it out. And then you can start putting the information into that petition if they are eligible for sealing or expungement. And then once you are ready to have the client join you, again, raise your green flag, give that client number to the runner, and they will bring the client in to meet with you. When you meet with the client, obviously introduce yourself and let them know that you're going to be walking through their record to determine their eligibility. The first thing you want to do is show them that chart and review everything that's on it and make sure there's nothing that's incorrect or there's no missing information. Sometimes, especially if someone has a really common name, we may have accidentally put something on there that is another John Smith. And so we want to make sure it's not the wrong records on there. We want to make sure if there's something that we missed that the client has a chance to say, oh, well, I also had this arrest in 1995. I don't see that, and we can update that chart as necessary. Then you want to explain what the difference is between expungement and sealing. If there are any offenses that the client is not eligible for relief, explain why and which offenses those are. And then again, if there's any conditions required before filing. At that point, if the client is eligible to file a request to expunge or seal, you want to finish that petition, go through it with the client. The petition will have a place for, address, phone number, email address, all those things. You want to make sure to put the client's information, not your information. The client's information should be in there so that they are getting notice if there's any objections. They're getting the notice once the order is entered, all of those things. And if they have an email address, please put that in there so that they can get that over email and they don't have to wait for it to be mailed to them. So once you've reviewed everything on the petition with the client, they understand it, it looks good, go ahead and have them sign it. If you're doing things on your computer, you can just have them electronically sign so they can type their name in to the signature line and then save that petition using their first and last name. And then go through that next document with them, and I'll show you what that looks like in a minute, and explain everything that's going to happen next for them. And then once you've answered all the client's questions, you filled out that next steps document, raise your blue flag, and a runner will come to save the petition onto a thumb drive. So they'll put their thumb drive into your computer, save the petition onto the thumb drive, and then take it over to the clerk to be e-filed. When the runner takes the petition to the clerk, the client should also go with that runner. The clerk will have some chairs by their e-filing station where the client can wait and make sure that their petition is actually successfully filed and they can get their court date and whatever information they need going forward before they leave. So have the runner bring the client over to the clerk's e-filing station. And then after the client goes with the runner, take a couple of minutes and fill out that volunteer attorney final report, including the time that you spent, and return everything to the client's folder. And once everything's back in the folder, you raise your green flag again, and a runner will come take the completed folder away, and they can bring you a new client to start working on. So just for your information for what's going to happen after the clinic. So Stacy mentioned that normally the clerk waits to see if there's an objection, and if there's an objection, at that point we'll set a hearing date. For the cases that are coming through this clinic, we have special dates set aside for hearings, and so the client is actually going to get a hearing date that day. So they will know that day when their hearing date will be. If they don't need to come in for a hearing, then the clerk will send a notification that they don't need to have that. I'm assuming. Sorry, Candace, if that's wrong. So these are the dates that are set aside for the hearing. So the client should have a hearing one of those dates. And I'm just realizing that courtroom is spelled wrong. I apologize for that. I do know how to spell courtroom. I just don't know what was happening in my brain. And the clients will have the opportunity to contact us if they do receive an objection and want some representation on that objection. So if you are interested in volunteering for the next stage and being part of the group of volunteers representing clients who get objections, please let us know. We would love to have you. And we can, if you reach out to Jessica at Pilley, who sent all the materials and has been, I think, communicating with you, she can get you set up to do that. So please let us know if you're interested in volunteering to represent clients with objections. Okay, so now I'm going to show you the different forms and walk you through what to do the day of the clinic. So I just wanted to point this out this is in your materials. This is a flow chart that we have created at Prairie State to help you walk through what's eligible for expungement and sealing. Stacy also included a similar flow chart that's kind of more horizontal. This goes top down, that goes left, right. Whichever one helps you think through this, feel free to use. I just wanted to highlight that this is in your materials and this is what it looks like. Next want to just show you the different forms. So this is the volunteer instructions. So again, this walks through in a little bit more detail everything that I talked about, so you don't have to remember everything that I've said. And this will be at your stations the day of the clinic. So I just wanted to get you familiar with what this looks like. I do recommend that before you come into the clinic, maybe the night before or that morning, just reading through this again to refresh your memory so you are aware of what to expect and what's going to be happening that day. Next is the next steps that I was mentioning. So this should be given to each client before they leave. After you've gone through their petition with them, check off the appropriate boxes. So if they have something ready to be filed that day, you would check this first box here. And then the clerk will fill in their court date, so you don't have to do that part. But yeah, just check off that they have something that's been filed, and then this gives some information about what they can expect. If they need to attach something else to their petition, so if they need a drug test or if they are able to waive a waiting period because of an education certificate, then you would check this box and let them know what is needed. In that case, they would not be able to file that day, but they would have to file on their own afterwards. So you have to make sure to give them the petition. So either email the completed petition to them or print it out. We will have printers at the event, so print it out for them to take home, whichever they prefer, so that they have that completed petition. We also have e-filing instructions that will be on the tables at the clinic, so you can give them the e-filing instructions and their completed petition, and then that will let them know what they have to do after the clinic to finish the process and get everything submitted. If they have a waiting period, you would check this box and list when that waiting period ends, when they would be eligible. And then finally, if they have things that are not eligible to be expunged or sealed, please list those here so that they're aware, okay, these things are going to remain on my record and they can look into whether they want to do anything else, like try to get a certificate of good conduct or another option. And then this just has some additional resources for the client. The last thing for you to fill out is this volunteer attorney final report, and this just helps us to understand what happened in each case. So include the client name, and then whether or not you prepared petitions for them. If you prepared a petition, how many records were included to expunge or seal, whether the client could file that day. If not, what is needed. And then there's just some room for some extra notes if you have any extra things that came up or things that you think should be noted for the client. And then please put your name. We really need to know who worked on each case for malpractice purposes. So put your name, and then again, that's where you can put how much time you spent on the case. This is, Stacey showed you a filled out version of this, but this is the blank chart that we'll be working on. Again, when you get it, this should be all filled in, so you don't have to worry about it. But I need you to be familiar with what this looks like. So it'll check off, whether they have eligible cases in DuPage, whether they have a cannabis case, whether they have a waiting period. So you will need to review this and make sure everything looks correct. But this is what that chart's going to look like when you get it. Okay, so, oh, and then I just wanted to show you, this is that cannabis cheat sheet that's in your materials that Stacey talked about. We will try for as many cases as possible to flag them if they have something that needs to be, where you need to do a motion to vacate and expunge rather than just expunging it. But if not, then you can reference this cheat sheet and hopefully it'll let you know what you have to do or what things are eligible. And while we're on cannabis, I will just show you, Stacey mentioned in her materials, she has the draft state form that you should not use, but we did create a template that you can use for a motion to vacate and expunge for those cannabis records, and it's fillable, so I'll just use it, fill it out with my information, pretending it's for me, and you'll see once I put the petitioner name in there, it fills in there. If I have a 2012 misdemeanor, then I put that in there. And then you would go through and fill out the arrest number and the agency and the charge, and all those things should be on the chart. And then again, the information is going to be filled in where necessary, and then you would just have the client type in their signature here to sign it, and again down here, and fill in their address and information. So that's why it's helpful if you have your computer and you can just pull these things up and fill in these blanks. But this is what the form looks like if someone has one of those eligible cannabis offenses to vacate and expunge. Okay, so then what do the other standard forms look like? So this, Stacey showed you briefly, but I wanted to walk through a little bit what you're going to be doing with each petition. And I hope this is, you're still able to see this, because I want to use this chart that Stacey provided to you. So you're going to get the chart and you'll look at all the things on the chart. So for this person, it looks like they have one case but 3 separate counts, and 2 of those counts are potentially eligible to expunge, and 1 of those counts is eligible to seal. So then what you would do is you go to the petition and you start and you click and select DuPage County. You put in the client's name. So this is Nancy Newsome. We don't have any other names used on these cases, so we'll leave that blank. Date of birth is 8/7/1991. Race and gender, I'm not going to fill in now, but you would obviously want to fill those in for the client. And then you were going to go in and fill in the case number. So 11 CF 123. And then Cece, do you, in this top part, do you differentiate the counts or just later on?
I just do it later on.
Okay, that's what I thought. So for this one, since it's all under one case, you would put that here. And then you would check, yes, I'm requesting to expunge or impound records. And we would go down to this box. And so the first one to expunge would be 11 CF 123 count 2. Oh, and okay.
Yeah, sometimes you got to put it over in the charge box because this form, unfortunately, is not always user friendly. So sometimes I put it in the charge. I'll put like parentheses CT1.
That's helpful.
Or you just handwrite it.
Yeah, or if you're handwriting it. And then the arresting agency is Naperville PD. Charge is possession. Oops. And then the date of arrest on here is 2/25/11. And the outcome, oops, sorry. And then the outcome was DA. So I'm not going to do the second charge because I think this shows you generally what it should look like. It doesn't apply for this case because she's only got 2 records, but if you look on here, you can see that that there's only room for 6 cases to expunge. So some people may have more than that. If they have more than that, you would check this box saying I have additional arrests or cases. And then you also need to fill out this additional cases for expungement form, which was also in your materials and we'll make sure you have access to at the clinic. And again, you would just fill in the name and other names and all of that and put in any extra cases here. And again, the client needs to sign this form, have their information down here, and save this as well so that they have both the petition and these additional cases. Same is true for sealing. There's only room for 6 cases to seal on the standard petition. So there's an additional cases for sealing form that you would have to fill out if they have more than those 6 cases. But going back to the petition, we would then scroll down and there's a bunch of questions that you have to answer. So just make sure you read through each one carefully because some of them are phrased a little weirdly. So for this, I was not convicted of any offenses I want to expunge unless. So the ones we want to expunge, she was not convicted, so we can skip question 3. For at least one case, I was arrested and released with no charges filed. There was a charge, that's why there's a case, so we don't check box number 4. For at least one case, I was arrested for minor traffic and released. That's not what we're dealing with here. For one case, I was charged but later acquitted. So that one we would check because she was charged and released without being convicted. She did not get qualified probation. She did not have a supervision sentence. She's not seeking a DUI or reckless driving. She doesn't have a supervision for reckless driving. And then this number 11 is only for Cook County, so you're never going to check that. But again, you want to read through each of these because which ones you check are going to be different depending on the cases. And then for her, yes, we also have records to seal. So we check yes. And we go down and do the same thing for sealing. So this one is going to be 11 CF 123 count 1. Again, it's Naperville PD. And this charge is possession of a controlled substance. The arrest date was 2/25/11. And the outcome was a felony conviction. So hopefully you can see where I'm getting all of this on the chart, and really you're just plugging it in from the chart onto the petition. So hopefully the chart is understandable and has all the complete information, and all you have to do is plug it in. But again, that's why you want to make sure you look at the chart, make sure you understand it all. And then again, if you have additional cases beyond the 6 that will fit, you would check this box. But this client doesn't, so we don't have to worry about that. And then you again go through these questions. So it doesn't look like, so this was terminated on November 1st of 2013. So, but she was not given supervision, it was probation, so we don't check this box. So 3 years have passed since the end of my last sentence. The end of her sentence was in 2013, so yes. And then she received a felony conviction subject to sealing. We do note that a drug test is needed. So for this case, before she could file, she would need a drug test. we are trying to tell as many clients as possible who need drug tests to get them and bring them to the clinic. So hopefully this client would have it. If not, she would just have to file this later on her own. So you would either need to print out or email the completed petition to her to file with the results of her drug tests. So you would have to hopefully always be checking this box because you're not asking to seal things that someone is on the registry for. This one I have not received a certificate of eligibility for sealing. That doesn't apply, so we don't check that. This is what you would check if someone has one of those educational certificates. Then you would check this box if she's eligible to waive that waiting period. And then there is this trafficking victim ability to waive a sealing. That's unlikely to come up. That's pretty rare. If you think that that's an issue or that has come up, then feel free to call one of us over and we can talk you through it. And then again, it's not a reckless driving case, so we don't have to check that box. You would have the client type their signature in here to e-sign it and then fill in, the client's information here, and that's the end of the petition. So you would save this person's petition onto your computer, call the runner over, and have them put it on to a thumb drive. I think that is all of the things that I have. So we are right at 4:30. I don't know if there were other questions.
I just chime in. I said in the chat that I would explain because my example is kind of confusing. And why is the now lead count say seal or expunge? And the reason is that with most counties, including our own, if you get charged with one case out of one arrest, out of one incident, all of those different counts are going to be under that same case number, one case number. In one of our neighboring counties, in some cases, in some situations, they will put each separate count. Like if I'm charged with possession of cocaine and a second count of possession with cannabis with intent to deliver, I'm going to have two different case numbers. So that makes it a lot easier so that I know on that first one where it's conviction and it's only eligible for sealing, that's easy peasy. And then that second case where it's only eligible for expunging, easy peasy if they're two separate case numbers. So in a situation where you know that all of those records arise out of the same arrest, you might draw an objection from the state's attorney. And we've had differing results from Judge Thielander, Judge Miller, the prior judges, all the way back to when Judge Creswell was hearing these some time ago, as to whether you can basically split the counts. If something is eligible for expungement, but the other cases or counts, the other counts in that case are only eligible for sealing, how do you expunge some and seal others? Judge Thielander has ruled in some prior cases that he will, if a case is eligible some of the counts are eligible for expungement and some are only eligible for sealing, that he'll go ahead and expunge all of them. And other ones, he's ruled that he's only going to seal it. One of the things that he talked to me about is, look, here's the situation. If I am charged and arrested because I have hit a cop, and that charge makes the whole case a felony. And after I've been arrested for hitting a cop, it comes out that I have great mitigation, it was an accident, whatever, I was suffering from some sort of mental break, whatever the case may be, they're going to dismiss that count, but it's filed under a felony number. But when I get arrested, I have a smoking pipe. Gosh, I am dirtying myself up here. That would never happen, but I have a smoking pipe and I get a conviction on that. It's just not patently fair for a judge to say, oh, I'm sorry, I'm not going to expunge a felony case. I'm only going to seal it, even though that count, the aggravated battery, was dismissed, and I got a misdemeanor conviction for a smoking pipe. So there are going to be equities and balancing here. So I always say, and some attorneys will disagree, and I respect that, go for the most. If you have a dismissed charge, go ahead and put it on the expungement side. Yeah, it makes filling out the petition a little bit more tricky, but go ahead and do it, because at the end of the day, it's going to be up to the judge whether to split the counts and say, okay, I'm going to expunge these, I'm going to seal others, or just give you one or the other, and that's okay. But go ahead and put it on there. I will tell you that in Cook County, I know they hold a different opinion, but I have searched the statute, and there's nothing that prevents you from asking. So
And I will, just to add to that, the flow chart I showed at the beginning that's in your materials, the one with like the pink and the yellow and green, that was created by someone in Prairie State who is in one of these counties where it's all or nothing. So you can't separate out the counts. So there is a notation on that that says if one count is not eligible or something, or one charge is not eligible, the whole case is not eligible. Ignore that, because in DuPage County, we can sometimes, or it seems like often the judge will separate those out. So ignore that one notation on that flow chart, because we can separate out the counts, and just make sure to designate this, count 1 is for expungement, count 2 is for sealing, count 3 leave off because it's not eligible for anything, or whatever the case may be.
Great. Well, huge thanks to you both for all of that great information. And of course, we'll be sending out a follow-up with the recording and the materials, so you have time to review them before the clinic. If you have not signed up and can sign up, please sign up. Please fill out the evaluation for CLE credit. And thank you so much for joining us today.
Thanks, everybody.